Commission. It's a little bit after 2 o'clock, so we'll get started. I want to thank everybody who's here in person and everybody who's here remotely through the Teams platform. The first order of business, I just want to make a couple quick introductions before we get to the minutes. First, I'm very pleased to, everyone knows her, but she's in a new position now, Jen Shukla, who was started last Friday, 2 Fridays ago.
2 Fridays ago.
2 Fridays ago,
Weekend.
as working as the Access to Justice Coordinator for the judicial branch. So Tim Sheeran's not here for that. He's talking to me, so he took her to Rob from the CBA. But the good news is the CBA quickly filled Jen's spot, and Attorney Sung Kim is here as our newest member of the Access to Justice Commission and is the Access to Justice Coordinator for the CBA. So thank you for joining us and welcome to Connecticut. You were in New York doing.
My legal work was in New York, but I've been in Connecticut 2018. So
Okay.
yeah.
Great.
Connecticut's helped.
Great.
Thank you for having me.
Thank you. All right, so with that out of the way, let's move to the review and approval of the minutes. The draft minutes were circulated to everybody, so you should have had a chance to review them. Is there a motion to approve the minutes? Stuart, is there a second? Attorney Bell, any discussion regarding the minutes? Being none, all those in favor say aye, or if you're on video, raise your hand.
Aye.
Any opposed? Any abstentions? Just as I Thomas abstained. All right, the minutes are approved. Proposal number 3 on the agenda is the proposal to amend the discovery rules and sundry process matters. So let me just remind everybody where we were on this. So there was a proposal that was made for the Rules Committee to amend the discovery rules in summary process matters. The Rules Committee referred the matter to the Access to Justice Commission to see if we had any comment from an Access to Justice perspective regarding the rules. There was, we discussed it at our April meeting. We tabled it at that time to give everyone more of an opportunity to think about not whether the rule was a good idea from a Rules Committee perspective, that will be taken up separately, but from whether the issues raised in Access to Justice concern, whether we as a commission should weigh in and comment to the Rules Committee. Since that time, after our meeting, the legislature passed an amendment to 47A-3A, including a subsection D, that requires the production of the ledger, which is the subject of the proposal, when requested by the tenant. So if it's an eviction case and the tenant wants to see the ledger, they make a request, it shall be produced to them. Subsequent to that, there have been discussions between court operations and the legal aid providers who had proposed the rule changes about whether there was some agreement from court operations standpoint and from legal aid about something to jointly submit to the Rules Committee and for consideration by us regarding our comments. You all have received in the last few days memos from both the legal aid providers who made the proposal and a response from court operations as to where they stand. And if you look at the proposals, there was 2 parts to the proposal. There was rule change proposals, 13-7 related to answers to interrogatories. And the idea here was to make the time period for responses match up with the more quick process that happens in summary process cases. So reducing the time to respond to 15 days. Court Operations has no issue with that proposal as set forth in their memo, and that'll really be from a Rules Committee perspective. As to that issue, as to the timing of it, I don't know if anyone wants to discuss whether that particular proposal involves access to justice or whether we can move on to something else. If anybody wants to discuss that from an access to justice perspective. Seeing none, then we'll move to 13-10, which also includes that same 15-day period. Again, the judicial branch's operations doesn't have any issue with that, so we would, the proposal would go to the Rules Committee. Does anyone want to discuss whether 13-10, which relates to responding to production for documents, 13-7 was in answer to interrogatories, whether 13-10 raises any access to justice? Okay, seeing none, then we'll move to the proposal 13-12E, which is the disclosure of the lease and ledger. There was Court Operations in their memo said that they had some concerns about this particular proposed new rule. And I don't know whether anybody wants to discuss this from an access to justice standpoint, or whether it's just a matter that we should not comment on and let the Rules Committee sort it out. So I don't know if anybody would like to have any comments. And I should also point out that we've invited members from Court Operations and from the legal aid community. Giovanni Shea is here, Bill Finn is here, Becky Schmidt is here. So they've been talking about these proposed changes. So if they want to weigh in, we'll certainly let them weigh in so that we can discuss that further, again, from an access to justice standpoint. So does anybody want to discuss this from an access to justice standpoint? No? Okay.
So,
Go ahead.
Giovanna Shea from Greater Hartford Midway. We do obviously see this as an access to justice issue, in part because the very large number of folks who are unrepresented in summary process matters. The statistics that were circulated to the commission show it's well more of 80% of the defendant tenants, more like 89% of peers who are unrepresented, while north of 80% of the plaintiff landlords do have attorneys. So even if the formal discovery processes, better match the pace of that litigation, it's not going to help the vast majority of unrepresented folks who are going to be asked to enter into repayment agreements to be reinstated as tenants, pretty much regardless of the specific nature of the claim against them in summary process matter. We think that, disclosure of lease and ledger is a common sense measure that would make mediators' lives and judges' lives easier. It's a lot like having a financial affidavit in a divorce matter. None of us would settle something with our credit card company without seeing the statement. I do want to say we are very open to discussing the specific language and structure of that proposal with Court Ops. I reiterated this with Attorney Pitt prior to the meeting. The proposed language of 1312B that you see in Exhibit A in a memo that was circulated was revised in response to feedback that we've received in previous rounds to try and make it more administrable. But if there is a sense that some of the language restricts judges' discretion, we can certainly talk about that. We have not yet submitted this to the Rules Committee. We're happy to talk about if the shall grant a continuance, if the ledger is produced on the day of trial should be a may, or if a structure that's no judgment shall enter should be structured in some other way. We were responding to the perceived concern that it might be a burden on the clerk's office to defer scheduling of trial until they saw that these materials had been exchanged. So we're very open to talking about that. I would rather talk with Attorney Pitt for ops now and get workable language before returning to the Rules Committee, certainly. And I also realize it's not helpful to draft this setting most of the time. But we do see it as for access to justice, the critical information needed for informed decision.
So, I guess what we were asked to do by the Rules Committee is to say whether we thought a particular proposal involved an access to justice issue. Because there's been some revisions to the proposal that hasn't been submitted to the Rules Committee. And there's an interest in discussing it further, and I assume that Court Ops is fine with having those further discussions, which it's not a yes. My inclination would be to report back to the Rules Committee that there may be a modified proposal that is made, and that therefore the commission doesn't feel like there's something that we should weigh in on from an access to justice standpoint until there's an actual proposal, then a new proposal that's been made, and we understand that at some point there will be something of a modified proposal. Does that make sense to everybody? Then does that not make sense? Then
No, I'm deferential, I guess. I'd be interested in the group. It's like, as a general matter, understanding the amendments to be made, there's a value in the commission supporting what, and I could be naive here, what strikes me as a very reasonable proposal. It does have an access to justice angle to it. I'm sure there's good counter arguments, but I guess, is there some reason we wouldn't support something like this?
So I'll speak. Judge Spader could not be here today. I think the counter argument to it is that there are a number of self-represented landlords, not as many for sure, but that there is a concern that having the mandatory disclosures could slow down the process for all parties involved and create an issue for some self-represented landlords that maybe don't have really good records and aren't well heeled in terms of having multiple units that they rent. They have one duplex, they rent half the duplex, and now are we making the rules difficult for them? Whereas if we don't do this by rule, the judges and the housing specialists can craft the appropriate remedy considering who the parties are involved in the case. And then if the court and the housing specialists have the ability through the mediation process or otherwise to put in deadlines, put in requirements, then it's better tailored on a case-by-case basis. I think that's what Judge Spader would say if he was here. I'm somewhat removed from the housing docket. It's been, 8 or 9 years since I did a housing docket case, but I'll ask Travis or any of the other court officers that said, did I fairly articulate what the concern is?
That's the issue with the one size fits all solution. It takes away the discretion of the court.
No,
It gets people into court later, which by virtue of just that time, that could cause additional problems.
So I think the concern is that depending on how it's drafted, could impact whether it's an access to justice issue or not. If there is something that court ops and works with the legal aid providers and everyone comes to agreement, yeah, this solves the problem and it's an access to justice and it solves the access to justice issue, then maybe our response would be, yes, this is a good thing for access to justice. On the other hand, it might be that the commission ends up somewhat split on whether it's an access to justice issue, in which case we might give a different response to the rules. That's kind of what I think. Judge Berger, did you have something you wanted to add?
I did. I think we need to be careful to distinguish
If
between,
you're muted.
according to this, I'm not.
No, still muted, Judge Berger.
Judge Berger, I'm dialed in and I can hear you, so it may be that the room can't hear us.
I don't think they have audio.
I mean,
Anybody?
Oh,
That's the same.
hold on a second.
Here.
Maybe on our end, just 1 second.
Can people hear me now?
I think it's an issue in the room, Judge. Those of us
Okay.
who have logged in remotely can hear you, but we can't, oh, excuse me, there's a meeting in here, yeah. Sure, go ahead.
How about now?
Good, Bert?
Can folks in the room,
Yeah.
can folks in the room hear us?
No,
Can,
Yes.
no?
all right, we need the IT person to come back up and call.
Maybe I need to
All right,
hang
so,
up and dial in?
No, Judge, you're fine
This is not
because
an
we can
orchestrated
hear.
attempt to mute you, Judge Berger. We'll just have to, we're having technical difficulties. We will come back to you, and to Attorney Heath and to Attorney Fair, which reminds me, I forgot at the beginning to do 2 other welcomes. Attorney Fair is joining us as a new member of the commission, as is Attorney Bhatia. So thank you for joining us as members of the commission. Is there anybody in the room here, or we don't need that technology, who would like to weigh in on this? Judge Thomas?
I can weigh in on this from a few different perspectives. One is, I was a longtime housing lawyer in Greater Orlando, right? I've recently been reassigned to the relatively small housing docket in Toronto. Now, I would tend to agree that there are concerns when we deprive the court of discretion to deal with continuances or with going to judgment where that's otherwise appropriate. But one suggestion I might have is, for years in practice, we would ask for stays. And so the stay sort of was addressed in the general discretion that important to stay a matter pending discovery, but that I don't recall was ever commemorated in the practice. So one path that sort of potentially leaves open the court's discretion to determine how to deal with this might be the commemoration of the concept of a motion for stay. If there is pending compliance, outstanding compliance to what you proposed elsewhere. But there are going to be situations where tenants have what they need and they're otherwise making decisions necessary to mitigate other consequences, including the accrual of attorney's fees, the accrual of additional rents, the fact that they're really just trying to get the situation over with. But if you have the ability to ask support for the discretionary stay, we can point to the practice book section. It's a little bit more formalized than something that's addressed with a generalized discretion. So just a suggestion for discussions.
Thank you. Now, I'm going to stop for a second because I don't know if we disconnected everyone who was remote or it's still connected. Everyone's still connected? Okay. All right. So we can't see everyone who's remote at the moment. I think we're pulling it back up. Anyone else in the room that would like to have any comment on this discussion? Okay, so let's just take a minute to see if we are able to get into technical issues resolved with the people who are remote.
Are you folks in the room able to hear us now?
Let's try, Keith. Hey,
Evidently not.
Apparently, I don't think you can hear us in the room. Judge Berger, I was just saying before, your connection, Judge Berger, is fine. I think it's all of us who've voted in, they can't hear.
It's good to know, actually. Well, we could have 2 meetings.
the same issue happened at the last meeting, but they were able to fix it. So I imagine they will in the next few
Oh,
minutes.
all right.
Just maybe to fill the void, but also like to help my low IQ on this. To reverse the back pattern, is it common that judges would enter an order where the tenant doesn't have access to the ledger? Like,
And
I'm
that's
just
the
trying to wrap my
problem.
head around, like, I get that it could slow things down, but do we want to be in the business if it's happening? I don't know if it is. Where we would enter an order against a tenant without documents, materials like the ledger.
So, Judge Thomas or
Like, I know,
Travis, you know,
It's not the method of resolution. So if you're, obviously, if you're going to trial, then it's the landlord's obligation to prove your case, which includes the production of the lease or ledger at that juncture. But, there's any number of other causes of action that have nothing to do with the claim, not been, which would include family rental situation, individual sort of allowed to stay in your home for a period of time, but there was never any rental obligation. Serious nuisance, regular nuisance, violation of the lease for other reasons in which the production of the ledger isn't necessarily material to the cause of action. Obviously, if you're proceeding to try to introduce your case on a violation of lease, non-payment of rent, central to that claim is the introduction of the lease and an introduction of whatever documents you have or whatever claims you have to support your claim of non-payment of rent or a violation of the lease.
so maybe that gets to focus with.
I think we have a mechanism that exists to accomplish both. I guess like it's the practice of how we proceed, and we make reasonable agreements based on kind of like reasonable available information. So we're always dealing with agreements, whether or not we have like available to do this kind of forensic autopsy of the situations to try to resolve it. Like I said, so similar to what Your Honor explained, based on
the ledger is material. That's where the you're bringing to the attention of the judge, or to the attention of the judge, the action. Our argument was that the mechanisms are in place to address the situation where it needs to be addressed. That without access to the motions for stay, other mechanisms. Oh, what's the status? All right, so I guess we still are unable to hear people who are remote, and IT is still trying to sort that out. So what we'll do is we'll come back to this. We'll move on to the next agenda items, and I promise that when we go through the next, after we go through the item 4 and item 5, we'll come back to this discussion and hopefully have a better sense at that point. So we'll see if the technical difficulties affect any of this item 4, 8 through D. So item 4 is the update of the subcommittees. We'll start with the pro bono subcommittee. Judge Stewart.
Hello, everybody. I don't really have a lot to add to my report that I gave in late June because I gave my committee the summer off. But one portion of it, I've divided our committee into 2 groups. One of which is doing listening tours with lawyers around the state, trying to find out what works and what does not, to get individual lawyers to do more pro bono and to get more lawyers to do pro bono. So in the late spring, we met with 2 large groups of lawyers from large law firms, and many of which have very organized systems for the intake of pro bono work and pro bono partners devoted to doing the organizing of the pro bono work, some of which were not quite that large and that sophisticated, but nevertheless, I think we all came away fairly impressed by their commitment to doing pro bono. And most of the larger firms in the state were represented. But when I say larger, what passes for larger in the state of Connecticut is roughly 50 lawyers or more. And so now we're making an effort to meet with people that are not large law firms. So we have, for example, a meeting scheduled for next Wednesday with 10 of the people who won the CBA Pro Bono Award in the past year that I purposely screened out email addresses. So all of those people are either solo practitioners or at very small, like 3 or 4 lawyer firms. So I think that we will, I just today circulated to them, a list of topics that we'd like to hear from them on. So we're hopeful that we will get some more input. And the reason that we're doing this is that I know in the past, there was a survey in connection with lawyers doing the registration every year, and having seen the results of that, I didn't frankly find them to be very informative. And I apologize to anyone and everyone in the room that might have been involved in creating the survey, but the bottom line.
Those of us who created it didn't find it very informative either.
Yeah, there was a lot of bitching, moaning about, oh, no, don't make this mandatory, or I don't have time in my life, or I'm struggling to keep my head above water economically, et cetera, et cetera. So not very useful in terms of how to figure out how to get more people to do pro bono and to increase the amount of pro bono lawyers are doing. So we're hopeful that we can do a few more of these listening tour meetings with other groups. So we have, kind of a good cross section of the bar. On the other side of what we're doing, we're waiting patiently, and I think we're going to have a meeting of this group for the results from the Bar Foundation's analysis. And from our perspective, that will tell us a lot more about what the needs are and what the demands are for pro bono services. So that hopefully, eventually, by the time we do our fall conference next year, we'll have a match of supply and demand. Those lawyers that are interested and enthusiastic about doing pro bono work and with the clients who need pro bono assistance. So that's my report.
Is there anyone else from the pro bono committee who wants to add anything to that? Okay, thank you, Judge Stewart. The self-represented access issues subcommittee, I don't know, Judge Dimiola, give it a try. See if you can.
Can you hear me?
No? All right.
No.
Sorry, we'll have to get back to you. The Law Libraries Law School Subcommittee, that's Judge Spader. He's not here, as I mentioned. I don't know if did he talk to anyone else on the subcommittee about providing any reports? No? Okay, all right, we'll skip that one. Legal Aid Subcommittee, Judge Thomas.
We've also been on a bit of a summer hiatus, but at the end of the summer, we identified 4 areas for our subcommittee to prioritize. We're going to break into working groups. The kind of concepts that rose to the top were the concept of the Pro Bono Academy, similar to the Bench Bar Symposium that happens on an biannual basis. It's a focus on pro bono training, half-day training events, sponsored, we hope, for the first time, or held for the first time in the fall of 2026, in which particularly new admittees to the bar would be admitted, offered the opportunity to choose a track with pro bono training covering areas of significant civil legal need. We also identified the concept of a pro bono training and MCLE rule change proposal. This would require new attorneys get past new attorneys in their first year of practice to undergo a certain number of hours of training, particularly in the provision of civil pro bono legal representation, particularly given that there have been rule changes around credit for pro bono representation as to MCLE. It seemed to our committee that it made sense then to provide some training, particularly as we have new generations of lawyers entering the bar, to have an opportunity to learn what that looked like. Eviction diversion builds off of the work of the National Center for State Courts that is presented to our subcommittee. We have identified through a series of discussions with Krista, Ty, Bill and Ariane, myself, some of the concepts that we would like to bring to a Connecticut Housing Board if we could. And a couple of things have developed in that area, which I think promising, one of which is we were wrestling as to where this might happen. I've since, as I alluded to earlier, moved to Rockville and I have a housing docket, so maybe that's an appropriately manageable place to introduce some of this on a pilot basis. And at the time of our discussions, the Unite CT program had largely closed down, but there, as I understand it, is now a new small eviction and foreclosure prevention program, limited in nature. And so I've been in touch with our mediator to try to open up discussions with the Department of Housing, trying to do something where there's more of a connection between available funding and landlords and lawyers who are active, the landlords and tenants who are actively in eviction over and non-payment rent. So stay tuned on that. And finally, self-guided forms. This is the concept that some might recognize as A2J forms. Yeah, we've looked at New York as a model where, you know, through technology and other query-based systems, court systems and websites are able to offer more of a walkthrough existing code forms, so kind of a TurboTax style model. And so those are the areas that we will divide into the working groups. The plan is to trying to sort people into working groups and do that in earnest over the next couple of weeks. And then those committees or working groups will start working and trying to make progress on these efforts.
Anyone else from that group have anything they want to add? I will say that I think, and I'll ask Ty and Chris to correct me wrong about this, that the branch is working on a chatbot feature for the website. They kind of, I talked to Lucio yesterday. He said that they're working on something that would add that where you could self-represented party in particular could ask questions and get a response to their questions. So it's like we all do on Google, but it would be a closed environment. So
yeah.
All
I
right.
think one of the common area or documents that we identified were the writs of Adida Corella that are presented in housing cases, which are currently handed sort of over the counter to individuals to fill out themselves. If we can use that as a model for some sort of guided process to allow completion with a little bit more information, might be a good place to start. Might be a way of alleviating some of the pressure on law librarians and other public facilities.
And you may want to follow up with Lucio about that and see kind of what he's doing and, you know, see if there's any particular direction you want to give him.
Thank you, I appreciate that.
That's Lucio, who's the head of our IT. Okay, so we're still working on the technical issues.
We could pass that now. If you guys can unmute somebody, I think pass it right now.
Okay, Judge Demioli, do you want to try it?
Sure. Can you hear us or me?
No?
Anything? Bueller?
You sound good to me.
Okay, let's,
Thanks, Tim.
Judge Willow, do you want to talk about the Access to Justice Conference?
Sure. So our subcommittee's been meeting. The plan is to have the conference sometime in the fall. We have an extensive list of dates that are available. I mean, the location will likely be the Legislative Office Building. There's facilities there, there's parking. You don't have to worry about refreshments for anyone because there's a cafeteria there. The tech usually works. There's usually the people. So it really just is, and it's free. So it checks all of our boxes.
So if I need to stop for a second, we had talked about doing it sometime next spring. I think the committee that working on the conference decided, and I think it makes sense that we should look for it next fall instead for a few reasons. One is if we want to do it at the LOB, which is free space and convenient space and parking, there's less conflicts in the fall than there is in the spring. With Jen just starting and as our coordinator, gives her time to kind of help and with the planning of the conference. And the subcommittees have all been working on really good ideas, and it gives everybody a little more time to put it together. And when we've done these conferences in the past, we've typically done them in the fall for a lot of those reasons. So that's so
Conflict with things like the Bar Association's annual meeting or the Judges Institute. There's a lot that happens kind of in the spring, and we thought that maybe fall would be more convenient. And there's plenty of dates available from September through November. So if people have input on, we're trying to avoid, there's a number of religious holidays that take place in the fall. So we're cognizant of the fact that there's other things that are going on. So if anybody has any input, if you've got some giant conference that's going to conflict with people who are interested in this plan for September, October, and November of 2026, let us know that. Then we'll try to avoid that. And we're trying to make this so that it's available and convenient for folks.
How we doing with you think it might work again, or?
I'm hearing audio now, so I'll leave it.
Okay, so Judge Demiola, you want to try being the guinea pig for a third time?
How's that?
Yeah.
Anything?
Stop, but.
Yeah,
Can you
it's
hear
too
me?
soft, but we do hear something, so.
Okay. I know my volume's up, so apologies to those who can't hear me.
There we go. All right.
Of course, we have feedback.
So the plan here, if this works, is Judge Demiola will do her report, and then we will go back to item 3 on the agenda. So Judge Demiola?
Hi, everyone. Like most committees,
On.
we took a bit of not much of a hiatus, but we did not meet regularly. We did communicate via email. We're working on our proposal, which will include recommendations to assist those who are self-represented, managed through the court system, specifically housing. So we'll address plain language. Our recommendation is, of course, to collaborate with Judge Thomas's subcommittee on any of the initiatives that they're moving forward as it relates to plain language and perhaps others. Also a navigator program, the potential of advocates available when housing court is not in session to assist self-rep parties understand the process, create slide decks and videos and other material that allow folks to understand what's going on the day of their hearing. So hopefully that will help. And hopefully we'll get that out to you soon.
Thank you. Anyone else from that committee have anything? So before we go back to item 3, which is the summary process matters, does anyone on the video have any comments or thoughts on any of the things we just discussed about the various subcommittees? Okay, I want to thank you all for your patience. So let's go back to item 3, and I will start with Judge Berger, and then Attorney Fair, and then Attorney Keith. Judge Berger.
Yeah, good afternoon, everyone. I think it's important to differentiate the notion of the judge hearing the case, a case, in our adversary process type of forum, with an unrepresented party coming to court for the first time, being pushed, and I use that word lightly, into a mediation process, not really knowing what's going to happen without, and generally speaking, we can all agree that the issue is always over money. Without having seen prior to that particular time, all of the figures that are involved. I've handled thousands of landlord-tenant cases. Most of them dealt with this particular issue. And in most of the cases, the defendant would say, I don't know about these figures. I've never seen these figures. So it seems to me the amendment to 1312B makes sense from an access to justice situation, because isn't this what this is all about? the person should feel like they are getting a fair shake at this. And if they are being sent to the mediator and they are being told that they owe $1,229 and they've never seen those figures before, and by the way, if we don't come to this agreement to pay it off over time, et cetera, you and your family are out. From an access to justice situation, it seems appropriate to have that continuance. So however we work on 12B, we need to keep in mind that that aspect, which handles most of our cases, the defendant needs to feel that this is a fair process. I am not in any way disparaging our housing mediators. That's not the point. The point is they are, for all practical purposes, the court. And this is what they're being told. And they need to feel that they're getting a fair shake. If they are smart enough or have the wherewithal to get before a judge, things do change. But that is not the case for most. They hear things like final stay. What does final stay mean? So yes, I would think that from the access to justice scenario, we think seriously about approving the 12B concept.
Okay, thank you. Attorney Heath, your hand up before. I don't know if you saw anything.
Yes, thank you. I'll also point out that I think Attorney Doherty has her hand up, but it did go up also, and they may not be visible in the room. I was going to make points along the same lines that Judge Berger did. He made them more eloquently than I could, so I'm not going to try to go down that road. I'll simply say that I think the counter arguments are not unreasonable, but I think that this change is the better option in the interest of access to justice.
Attorney Fair.
I did not have my hand up, but I will also speak in support of His Honor and Attorney Heath's comments with respect to this being something that I think is integral to access to justice.
Attorney Doherty.
Thank you. And I wasn't at the last meeting, but I want to strongly agree with Judge Berger and others who have spoken of this as an access to justice issue. I think the legislature created this new right for a reason. And I think it's about basic transparency and people having the information they need. And if there are, if what we're contemplating is repayment agreements, it seems even if you have an unrepresented landlord, you need to create an account of what you're charging people before you insist that they repay it. So I strongly agree, first of all, that this is absolutely an issue for our committee, and I very much support the amendments.
Anybody else want to weigh in on this? All right, so the question then becomes, is there any action that anyone wants to propose that we take right now regarding this? Or do we want to see what happens with further discussions between the legal aid providers and court operations in terms of a proposal?
Not inappropriate.
I'm sorry, Judge Berger?
Not inappropriate to wait to see what happens as a result of those discussions.
Does anyone else want to be heard? Dean Bellini? No.
I was going to suggest the opposite. If there is consensus in the room, I have no idea if there is. It might be valuable to the discussions to know whether and where in general the commission stands, as opposed to sort of, it's like a wait and see with a signaling.
My general sense is that the underlying issue we all agree on, which is that all of us in various regards have seen the claim for inflated sum of money that upon the production of a ledger or at trial ends up falling apart. So I don't think anybody disagrees that it's a central matter. There should be some mechanism by which that information is shared. And I would agree with Judge Berger and others that that often happens in the mediation context. I think what I'm hearing from reading the court operations response and then sort of anticipating what goes to the rules committee that needs to get approved by all the judges of the Connecticut Superior Court at its annual meeting, is that when you sort of tell a group of judges by rule, you've lost the ability to manage your docket by deciding how to handle continuances, or you don't have the right to enter judgment by virtue of the practice book provision. That probably raises some issues just from a judicial discretion standpoint. So there's probably a path forward through that, one of which might be the concept of formalizing the concept of a stay. So it doesn't prevent the entry of judgment, but maybe stays proceedings while you have that compliance. That allows everybody to take a deep breath, make sure the information is shared. And I'd also note that some of the proposals are that, for example, when there's a mediator step, and oftentimes during the mediator canvas or the standard mediator stipulation language that they put at the bottom of their stipulations, there are certain representations that the mediators will make. So if what's added to that is a mandatory disclosure by the mediator, yes, the tenant has been provided with the ledger and the accounting and had the opportunity to review it. I think that's also a potential path forward. Whether that requires a rule change or not, is another question. So I think we're all in agreement. The tenant should not have to go to judgment with no information about, the validity of their the claims against them. It's just the question of how do you make that work within the parameters of our discussion, the walls or the rails.
What he said, like,
Yeah, no, I, that's what I was gonna say. Again, not as eloquent as Judge Thomas said, but nobody wants a party, particularly an unrepresented party, to enter an agreement that is inaccurate or which they didn't have an opportunity to text. And nobody wants anyone to feel forced that they're entered into to an agreement. And when I've worked with the housing mediators, they do, the work they do is unbelievable. And in usually very small offices with parties sitting on top of them practically and trying to make sure that everybody is comfortable with the agreement. And then the judges will typically canvass to make sure everybody is comfortable with the agreement. That doesn't mean we can't do better. And it doesn't mean that we can't do more to ensure that that people feel like they have all the information they need to make an informed decision. So I don't think anybody would disagree with any of that. The issue, though, kind of the more narrow issue that we have today is we've been asked by the Rules Committee to provide an access to justice comment on a proposal that is in the process of being modified. And I think that I can, unless people feel otherwise, I can certainly convey to the Rules Committee that we believe from an access to justice standpoint, it's important that people have an opportunity to review agreements and have all the information before entering into agreements, that the legislature has done something that to address that issue. And there's work being done on a modified rule, and whether that rule will do enough to satisfy the members of the commission from an access to justice standpoint, we just don't know yet. And that when the rule is presented, when the proposal is presented, whether agreed upon or not, if they want us to then review it again and weigh in, we're willing to do that. Is that a path that people are comfortable with?
That makes a lot of sense.
General nodding. Does anyone feel otherwise? Say, well, want to be heard otherwise. I don't want anyone to feel forced that.
That just has a
Yeah.
process timeline.
Yes.
How is this structured as far as when a decision is made by the Rules Committee?
So the Rules Committee, the last meeting for proposals to get, and I've just taken over as chair of the Rules Committee this year, so it's been a while since I've been on it. I know Judge Stewart's been on it more recently than I have, but I think March is the last time that something can be proposed by the rules committee, because then it has to go to a public meeting and then be presented to the judges. So we still have time
That's
to do that. We're gonna talk about our next meeting, which I'm hoping to do in November. And hopefully between now and then, over about a 6-week period, we can have that discussion, those discussions take place and maybe come back and look at a new proposal at that point. If there's something that, has been agreed upon, or if it hasn't been agreed upon, it's just that this is what we're submitting to the rules committee. Okay. Anybody else have any comments on it? Say anything? One,
I can be helpful to
Yeah.
those discussions and have join whatever is.
thank you for volunteering. I was gonna volunteer, Judge Thomas, but since you volunteered yourself, that's even better. So, okay, so that's, how we will, proceed. Thank you, for both the legal aid providers and for Court Ops for continuing to work on this. You know, it's always better if we're able to find, a common ground and finding something that works for everyone. And thank you, Judge Thomas, for being willing to provide the judicial perspective, and for Travis providing the immediate perspective. Okay. So, that's what I'll report to the Rules Committee next Monday, at that meeting. Or I'm not even sure if it's on the agenda for October or November, but I will provide that information in the time of session. The next item on the agenda is our next meeting, which I was going to propose we do for November 12th, which is a Wednesday. That's it. And we'll do it the same way. We'll be in person and by video, and that's the only time we've ever had an issue with the video. We were able to sort it out, so hopefully we'll have it good to go when we get back to the phone.
Justice Bright,
Yes,
will there be a way to make comments or somehow vote prior to? I will be out in Denver, Colorado, awaiting the birth of my grandson. So
sure.
how will I vote?
Yeah, I think there's a couple things we could do. One is if there is something that is ready to be presented for us to look at on November 12th, we can try to circulate that ahead of time so people can provide comments. Like they did this time the comments were just from legal aid and from Court Ops, but if members want, if anyone who could attend the meeting wanted to have their comments submitted, you can submit that to Nicole, and then I can deliver your comments at the meeting. The other thing, Judge Berger, is if you mentioned you were involved in housing for a long time, if you wanted to be involved in reviewing the back and forth, you know, we can have you give input as those discussions are happening.
Happy to help.
Okay,
And thank you.
all right. Anybody else? Anything? Okay, thank you all, and we will see you on November 12th. We are adjourned. I was your motion. Second, we're adjourned.